It's all because Texas is 3 strikes and you're out law. I don't
Been
know.
to prison in Missouri multiple times.
Yes.
So that makes it down here 25 to life.
Yes, sir.
All right, the court calls F17223 State versus Eric Clark. Mr. Clark, earlier today, after you were at the courthouse, the court sent you a waiver of counsel because you indicated that you didn't want Mr. Felon representing you. The waiver of counsel is a document that the state of Texas promulgated in 2007. Says that I have to advise you of certain matters, that you have a right to be represented by an attorney. You have the absolute right to represent yourself. There are dangers and disadvantages to self-representation, such as the fact that you haven't been to law school, you may not know the rules of evidence, procedure, things of that nature. You also have a right to hire the counsel of your choice if you are able to do so. If you're indigent and unable to afford an attorney, the court appoints one to represent you, and in fact, I've now appointed 2 to represent you. The range of punishment in this case, if as I recall, is 2 to 10 years in the penitentiary. However, the state has filed a Brooks notice indicating an intent to use 2 prior final felony sequential convictions, which would mean the range of punishment is 25 years to 99 years or life in the penitentiary. And so, first of all, Mr. Clark, do you intend to represent yourself in this matter, or do you wish for Mr. Felon to continue to represent you?
Represent myself.
All right.
I thought one of the enhancements got dropped off.
I am not aware of that. If so, it would make it 2 to 20 years.
That's what I'm saying. It was supposed to be 2 to 20 because Greg Hill, whenever he was my attorney, said that one of the enhancements has dropped off.
I don't know. I'm not privy to that. If you have 2 sequential, it would be 25 to life. If it's 1, it's 2 to 20, and those have to be proved just like guilt or innocence have to be proved.
I've only been incarcerated in Missouri. I was never incarcerated in Arkansas. They were trying to enhance my other charge for Arkansas.
Yeah.
Your Honor, we have filed a first amended notice of enhancement paragraphs. In other words, an amended Brooks notice. It looks like there was an Arkansas one contained in their original enhancement notice. However, there are 2 sequential Missouri convictions now alleged in the enhancement notice. And so it is 2 Missouri convictions that will be used that enhances the punishment range on this third-degree felony up to 25 years to life in prison.
All right. So there's no allegation of Arkansas, Mr. Clark, but there is an allegation that you twice in sequence went to the penitentiary in Missouri. And so that's where the 25 to life comes from.
But because I've been to prison in Missouri, they can enhance it 25 to life?
Yes, sir. Doesn't matter where else it was. I've actually, that's true whether it's sex offender registration, no matter what it is, the full faith and credit clause.
How come I was offered a 10-year?
I don't know. I don't get involved in plea negotiations. What was offered before?
Can't we resolve this instead of going through all this trouble and hassle? Like, can't we plea out to something? Agree to plea out to something, Pratt?
I agreed today to lower my offer from 30 years down to the statutory minimum, which is 25. That's the lowest that a jury could give him if convicted. They can give him 25, 30, 55, 95, life, anywhere from 25 to 99 or life. And I offered to resolve that matter today for the minimum, which is 25 years. It is not an aggravated offense. And so he would be eligible after 1/4 of his sentence. And if he gets 2 for 1 good time, that would equate to 1/8 of his sentence, which is less than 4 years. It's barely over 3 years. Plus, with the time credit he already has, it'd be less than 3 years before he'd be eligible for parole. That obviously doesn't mean they would grant him parole at that time or any time, because that's up to the parole board, and neither I, the defense, or the court has anything to do with that.
Can we work out something today on a 15?
25 is At this stage, 25 is the lowest that it would be offered.
There's no way to get under 25. Like, I'm willing to resolve this. We don't have to go to trial. We can get this taken care of. Like,
I'm
willing to resolve it for that minimum of 25, but no, I'm not willing to do anything less at this stage.
Well, that's what I'm going to get offered anyway at trial.
No, I'll be asking for significantly more, but it'll be up to the jury.
Now, the jury can start at 25. That they can't. They're not limited to 25. I want to make sure you understand that, and that's why I went over the range of punishment. It starts at 25. It goes to 99 or life. That's why I want to make you fully aware of where we are today. As Mr. Pratt said, it's not an aggravating offense. In Texas, an aggravated offense requires 1/2 calendar to be served.
Well, how much time would I have to do on the 25?
You'd have to do about little over 3 years before you would be eligible for parole. I can't promise you when you would be granted parole. I have nothing to say about that. They don't ask me, and I don't have any input. That's completely up to a board called the Texas Board of Pardons and Paroles.
And then I believe he's got somewhere in the neighborhood, and you would know better than I, but somewhere in the neighborhood of 6 months worth of credit towards that sentence already.
Right.
So you'd have to do about 2 years and 10 months, and then you would be eligible for parole.
It just seems extreme for evading, though.
Well, it's all because Texas is 3 strikes and you're out law. I don't have any say so over that. So I just am trying to get this issue on this waiver of counsel resolved, Mr. Clark. And so,
all right, Brad, I guess let's just get this resolved. So I'll be able to talk to you coming up. We can resolve this.
If it's not resolved now, then I maybe would resolve it, but it wouldn't be for something as low as 25 years. So it's either.
I'm trying to get this resolved with you.
Well, Your Honor, if I could have then a moment to visit with his counsel, or if a waiver is approved with him, because I can't deal with him. That his counsel.
I've approved the waiver. I'm going to keep Mr. Felon as standby counsel, but he does not have to be involved in the plea negotiations. Mr. Felon, if you want to step out for those,
well, Your
I'm
Honor,
going to step out.
Your Honor, before you do, just wanted to make sure that he's had his full Feretta, his full warnings and admonishments regarding representing himself. And if he has, that's just fine with me. I certainly
let me go over it. Yeah, let me go over it just to make 100% sure. Mr. Clark, I may have forgot to say something toward the end, actually. As I said, you got an absolute right to represent yourself. You have an absolute right to hire a lawyer or have a court-appointed lawyer. Mr. Felon is still here as your court-appointed lawyer. If you and Mr. Pratt go into these plea negotiations and you decide you want to go back and still have a lawyer, I will keep Mr. Felon on the case, and you will continue to have a lawyer. You can withdraw this waiver of counsel at any point, because as I said earlier, there are dangers and disadvantages to self-representation in these cases. So that's something I want to make sure that you're aware of.
I'm just trying to get this resolved. At least amount of time I can get.
All right. Well, let me let you and Mr. Pratt visit. Mr. Felon and I are going to step out of it for the moment. And when I'm told I'm needed again, Mr. Pratt, if somebody will send just a message.
We'll notify your office. Yes.
All right. Thank you.
So just to be clear, I leave.
It doesn't matter to me, Damon, if you stay or leave, either one at all. So
just for the sake of experience, I will shut up and stay here.
All right. So, Mr. Clark, if we're going to do this, then what would happen would be I'd prepare this plea paperwork and have it sent down there to the jail for you to review and to sign. If you want an attorney to go over that with you, then I can provide a copy of that to Mr. Felon as well, and then I can, zap myself out so the two of y'all can go over it to make sure you understand everything.
You said I had to get resolved today.
That is correct. I will offer the 25 years if we're going to sign off and get the judge to approve the plea and be done with it today. Otherwise, I'm continuing to prepare for trial on Monday. This is the only case set for trial on Monday. And so I'm not going to offer something as low as 25 years if we are not getting it resolved today.
I guess I'll take the 25 today.
All right. So I'll prepare the paperwork, and that's what it'll say. It'll be the 25 years on there. When the judge goes over it with you, he'll also explain that he'll give you credit for all the time that you have, which would be from when you were originally arrested, and then you bonded out, and then we picked you up shortly thereafter. We had you in, and then you bonded out again. And so, but then you've been put back in. So you'll get credit for all of that time that you've got coming to you. All right. All right. Well, I'll fix that up right now. We'll just stay here on here because we're not ready for the judge yet. But I've got plea paperwork here that I could somewhere in here.
Further, is this the best you think I should do?
My guess is that
just since you've asked me the question,
Right.
I do not think in Texas in Hill County that you can do better than 25 years on this case.
Okay.
I think that 40 and above would probably be a reasonable guess. I cannot guarantee that, but I don't think it's going to be close to 25.
So take the 25 as a good offer.
It's the best offer that you could possibly get.
All right, I'm gonna go ahead and take it then.
all right.
And
now that you've made that decision, I'll just say that I've had a couple of aiding arrests that were habitualized like this, and one got 55 and one got 65. So just so you have an idea, I wasn't going to even mention it to you before. Not that I'd be prohibited from doing it, but
may I speak on this as well, just to let
Certainly.
you know, though, that you're not getting screwed as bad as you possibly could have because there's no deadly weapon finding.
All right.
As Damon knows, I have done that before, and if I allege a deadly weapon, then you have to do, and the jury finds that there was a deadly weapon used, in this case, say a vehicle that was capable of causing death.
What happened to like the time whenever it dropped down 2 to 20 and like I was offered a 10 on that one Zoom with you? Like,
well,
I told Greg that I wanted it that time, but he wanted to pursue further evidence and some shit. And then he jumped off my case. That's why I was so mad that day. Like, I wasn't mad at you guys. It's just Greg was giving me the runaround.
Well, I think the 10-year had been withdrawn. I think there was a realization that there was an issue with the Arkansas prior because it was a probation case. Their criminal history was somewhat confusing in the way they had it written, and I think when that was realized, that offer had been withdrawn, if it ever was made, and that was prior to that hearing that we had with Mr. Hill on getting off. All right, so let me see here. Take me just a couple minutes here.
So I'll be eligible for parole in like 3 years?
Yes.
All right.
Well, let me clarify that as well.
Right.
If you get good time, if you get to the prison and throw poo at people and cuss them and act a fool, you can do a lot longer.
All right. I get it.
Okay. That would be not getting good time would be automatically doubling the minimum.
I'll get all my good time here for the jail, and then I just got to have good time down there.
That's how it could become worse if you don't get the good time.
Right.
What they do here is they let the prison know how many days you've actually been in our facility here.
All right.
And then the prison makes determinations regarding good time.
All right. So I'm looking at probably, since I have like 7 months in already on it, I'm looking at I'm looking at like almost 3 years before I'm eligible for parole, like 2.5 now.
Yeah, somewhere in the neighborhood of 2.5, could be 2 years and 7 months, 8 months at the tops, something like that. basically whatever 1/8 of 25 is. 1/8 of 24 years is 3 years. You got one more year, so
It's
1/8 of that, so a
37.5
little bit
months.
over a month. Go ahead,
what?
Damon.
37.5 months is 1/8.
So I'm already got about 7 months in. So I'm looking at like 2.5 years. 30 more months.
Yeah.
2.5 years. All right, that ain't bad. Get this shit over with. I just want to get the shit over with. Right, there's no way to come down at 25 at all. A little bit.
No, sir. And quite frankly, if Damon hadn't twisted my arm today, I wouldn't have come off the 30 that I've been at before. As he can tell you, my typical practice is once I get within a week of trial as I go up. And so ordinarily I would have gone to 35 at this stage, up from 30. And then I would have gone up to 40 come Friday. And then I'd either do nothing or you know,
All right.
50, you know, come Monday once I got a jury that's already had to take off work and show up here. So frankly, I did it because there had been, you know, a variety of issues. I realized that you had some stuff in another state and maybe, you know, whatever issues there were. And I was hopeful to try to get it resolved peacefully like this. And frankly, and something that would save the taxpayers some time. I've already invested, frankly, a fair bit more amount of time because I had this file at home this weekend as well.
All
but in any event, that's kind of where we're at. Let me make sure I've got everything on this list here. I have to check off video recording. Something.
Ridiculous. Huh? No.
I'm about to sign it and date it.
All right.
And then what we're going to do is one of my secretaries will scan this document into the computer and they will email it down to the jail. There, they'll print it out. So you'll have an actual hard copy in front of you for you to go over. And then once you sign that, they'll email it back to the judge so that he'll have it in front of him when we go through the procedure.
When will it be finalized?
Here in the next, well, we're going to send it to you. You'll sign it. Send it back to the judge. He'll come back on. We'll go over it, and once we're done all that, then he'll be finalized right then and there.
All right.
So it'll be finalized here this afternoon.
Okay.
You know, here hopefully in the next 20 minutes or something. Basically, the longest part is going to be for them to print it out and bring it to you, and you to go over it and sign it.
All right.
Because the judge, he's familiar with them, obviously, because he's done thousands of them. And so he'll get it back and then he's going to go over it with you to make sure that you've understood what it is that you've signed, which will be stating that I'm pleading guilty to the offense of evading arrest with a vehicle, that I'm pleading true to the 2 prior Missouri enhancements set out in that notice of enhancement, and then that you are entering a plea of guilty voluntarily, and that you're waiving your right to appeal. In other words, you can't change your mind next week and go, you know what, I want to appeal it. You can still, I guess, attempt to appeal it, but basically you will have in this document waived your rights to appeal. And so, your attorney or somebody else can advise you on that. I can't give you legal advice regarding that, but basically you're going to have waived your right to appeal. And so it'll be finalized, in other words.
And there's 2 layers of that, because you've also are accepting something less than the maximum in this case, and by law that on a plea bargain, that is also a waiver of appeal.
And like I say, if you want, you can go forward with it where you're doing it on your own, or you can go forward with it where Mr. Felon is your attorney advising you regarding those things, and I can get off this screen and have them take me out where if you got something that you want to ask him, you can. I don't care. Or I can get up and walk out of the room if you got something you want to ask him without me in here, or I can have them turn me off. Whatever you
I'll
want.
be happy to help either way. Whatever you want to do, you're in charge. I'm here as a resource.
I was just trying to make sure like this is legit, like the best offer I'm gonna get. Like,
it is.
It is.
I'm a man of my word.
It just seems so extreme, Pratt. Like why I'm getting so much time for evading. Like I wasn't even trying to evade that night. Like
some people certainly do feel that way about the way that it is in Texas, because not every state by any means is like that, and frankly, perhaps not even every county in Texas would do something similarly. But it is the state law, and that's what we do here. And frankly, the juries here in Hill County, understand that part of the law, and they would do whatever's appropriate. In punishment, you'd be able to bring up whatever you wanted to. I would be bringing up things like the fact that you have 11 prior felony convictions in Missouri, plus that you got pen time on, plus a couple in Arkansas. So this is your 14th felony, not just your third strike or even your fourth or fifth or sixth. It's your 14th. And so, a jury would do whatever they think is appropriate in that case. And it certainly could be much more than 25.
I guess here's the paperwork.
Well, that's quicker than I expected.
Yeah, that's magic.
It's me, man. All right. You're going to sign right there where it says defendant signature.
They want me out of here quick.
And take make sure, don't sign anything before you feel comfortable with it. And if you got any questions, feel free to ask Mr. Felon. And again, if you need me to step out or something, I'll be happy to do so. Otherwise, I'm happy to stay in here and visit with you.
I'm trusting you for this fucking taking this plea deal, man.
All right, so you're going to sign there.
I'm just trying to get this shit done. I want to go home to my family.
Fair enough.
And you are a citizen of the United States.
Yes.
Right there. And right there. Okay. Then you're going to sign right there. You're going to sign right there. And then you're going to sign right there and put a good address and phone number if you have one. Do you have a phone number you want to put down?
No.
That's fine. Okay. All right. I'll get these right over, Matt.
All right, I signed them, Matt.
Well, actually, you were right probably before when you said my name, and she was wrong. It's Mark.
I mean, yeah, Mark. I'm sorry.
Yeah. No, she said that.
I'm sorry.
She misspoke. There's a judge up here in a different court named Matt, and that's probably what she got confused with.
All right, so this is over with now?
Well, not yet. The judge has got to come in and then and approve it. But she's about to email that to him, and so I'll have my office let him know to expect that to be coming now. I'll go tell them to call down to his office.
25 years, dude. So further, this is honestly the best that I'll be able to get, you said?
I would think at jury you're not going to get less than 40.
So then I would have to do how long? That's even more, a lot more. Ain't it?
Yeah.
So, all right.
And
all right, that's fine.
If y'all are talking and need me to step out, just let me know.
No, you're good.
All right, well.
Just can't believe I'm getting that many years for an evading charge. Like,
Well, it may not seem like a bright side, but on the bright side, it's anywhere from 25 to 99 or life, and is often explained to a jury. The middle point of that is 62 and a half years. And you're getting the very minimum that by law a jury could give you if they found you guilty and found those enhancement paragraphs to be true. And I have certified copies of those judgments, as well as your fingerprints from Missouri, and an expert to testify that's that to prove up those priors of yours. And so if they do find you guilty of that and those enhancements, that's the least they could possibly give you. And so basically be like you had a jury and then won out and got them to give you the very best possible sentence under the law. So I know it doesn't seem that great, but like
but I mean, all my offers were a lot lower than this before.
Well, I'm not sure what all, my assistants had previously offered on this case. One of them was handling it. I took this case because there was a sex case that was going to go to trial. And so I took this one to go to trial in case that other one fell through, which it did, which is how we got back up here. And also there was an issue in looking at it with that Arkansas prior. And if you had only had one prior conviction, then instead of it being a 2 to 10 range, it would have been 2 to 20. So you could have gotten anywhere. So you could have got, so 10 would have been the middle range of 2 to 20. Right now, your middle range is 62.
2 to 20.
Well, if it was 2 to 20 range, then yes, 10 would have been in the middle. Right now, because you've got the two sequential Missouri ones,
what does that mean, the two sequential Missouri ones?
The sequential means that you commit an offense and you get convicted, and then you committed another offense and get convicted. In Missouri, you had a variety of offenses with different offense dates. And you had...
I've been to prison in Missouri multiple times.
Yes.
So that makes it down here 25 to life?
Yes, sir.
That's crazy.
It is pretty wild. Really, just any two sequential ones make it 25 to life. And you had, between 2009 and 2013, you had 11. You got sentences of 5, 5, 5, 5, 4, 5, 3, 5, 5, 7, and 2. And then you got one in 2020 that you got 5 on. You had the 2 felonies in Arkansas, but you didn't go to prison on either one of those. I think in the original enhancement notice that the judge was talking about, the Brooks notice, it had alleged one of those Arkansas ones, which they mistakenly thought was. That's why they filed an amended notice showing that the sequential Missouri ones that made it 25 to life. And so, like I say, here, you're way past that minimum of 2 sequential, and as you mentioned, you've got a number of them there.
Yes, this don't make any sense. I've never been hammered so hard over something so petty in my life.
Texas is
I won't be back to Texas. Will not be back to Texas.
I expect we'll see the judge any moment now. I talked to my secretary, and she was going to call down to his secretary and let him know that
What all else are we waiting on?
Well, once you sign those papers, that lady was going to take them back to a scanning machine and scan them in and email them to the judge. But you saw how quick it got down to you, so hopefully it'll get back up to them that quick. And if so, then he just is going to print it out and come back in here and sit down, and then he's going to go over it with us.
Can I have time to use the restroom real quick?
I don't know.
I got a piss.
I can't tell. Obviously, it's up to the folks down there. But
I'm gonna see if I can go use the restroom real quick. I'll be right back.
You think we got 2-3 minutes?
Yeah, we got 2.
Yes, sir, I do, and I'll let the judge know that I said it was all right.
Okay.
Mark, have you seen that having to pee is actually more dangerous than being? I saw a thing that having to pee when you're driving can be more dangerous than being drunk.
I'm sorry, Angie was talking to me, Damon. She was telling me that the jail had sent it to the wrong email address, but they did send a copy to us, and so she's now forwarded it to the judge's office. Good. That's what the delay was.
Okay.
And we'll see if that mistake has given him so much time that he's now going to change his mind. But
No, I don't think so.
I didn't want to let him go, but I wasn't going to make him pee himself either. So I don't know. We'll see what happens there.
I think it's.
Well, it's the best outcome for him. Your Honor, he needed to go to the restroom.
Okay.
I told him it was fine.
Yeah, no, I'm fine. I just did the same thing myself. So.
I think they accidentally sent the documents to just back to my office. But Angie got a copy of that, fortunately, because I don't know that I would have checked for a while, and she forwarded it on to your office.
Oh, perfect. I didn't know what happened with them, but
so
that's fine.
My understanding is he's doing this plea at this stage pro se.
Yes.
Is that right? All right.
Yes. Yes, I had approved the prior.
All right. Now, obviously, I don't have a copy of that, but my understanding is that when I heard you say you approved it, that you've approved and signed it. And so.
Yes, sir.
All right. I'm going to pull up a copy of those documents just to see if he signed everything.
He did. I've been through him.
All right. Thank you.
All right, Mr. Clark, I finally got those papers, so I will proceed to F 17223 State versus Eric Clark. Mr. Clark, my understanding is you and the state have reached a plea agreement for that minimum of 25 years. Keep in mind that is the minimum. When the court accepts it, there will be no, and I am going to accept it, there will be no right to appeal. You've proceeded today at this stage without an attorney based on that prior waiver of attorney that you signed earlier and that you told me you wanted to go forward on. And is that what you still want to do?
Yes, sir.
You've told me that you're guilty, that the two priors are in fact true, that you'd be sentenced to the 25 years and you would get credit for any and all the back time you've got coming. Is that your plea agreement, sir?
Yes, sir.
And of course, basically that means we're done here today. Mr. Pratt, does the state have any evidence it wishes to offer?
Yes, Your Honor. The state offers as State's Exhibit 1 the plea admonishment documents that the defendant has just signed, which contain a written judicial confession. All
right, that's admitted. Then Eric Clark, based upon your plea of guilty, true to the two enhancements and to the introduction of States 1, the court does in fact find you guilty, finds the enhancements are true. Based upon our conversations, of course, I believe that you are in fact competent, and based upon your waiver of counsel, I find that was freely and voluntarily done. You'll get credit for all the time you've got coming. They'll bring you up here probably this Friday to sign the judgment. Look at it because it'll have your day's credit on it. If you don't think they're right, you let me know so that I can take a look at it as well. All right, sir?
All right, thank you.
Thank you. We're in recess.
Thank you. Good luck to you now.
All right. Good luck.
All right, thank you, Pratt.
Yes, sir.
If y'all
Mr. Pratt.
If y'all can send Mr. Pennington in, please. Yes, he's through. If y'all can send Mr. Pennington in, please.